Good day. This is Daniela Ellerbeck, and with me is Liesl Pretorius. We are both admitted attorneys, and we are working as legal advisors to Freedom of Religion South Africa, commonly known as 4SA. This week, we're discussing the practical implications on the religious sector of the General Laws Anti-Money Laundering and Combating Terrorism Financing Amendment Act, commonly known as the Anti-Money Laundering Act. Now, this act was introduced as a bill in Parliament last year, now that's 2022, to prevent South Africa from being grey-listed by the FATF for not having strong enough laws to prevent terrorism financing from happening in the country. And this grey-listing would have had serious consequences on money flowing in and out of the country. And after a brief but intense parliamentary process, President Ramaphosa signed this bill into law on the 21st of December 2022. Liesl, can you highlight for our viewers some of the issues that 4SA raised when we made submissions and arguments before Parliament on behalf of the religious sector?
Certainly, Daniela. The initial version of the bill provoked an uproar from the non-profit sector because it proposed, amongst other things, mandatory registration with the Department of Social Development, or DSD, and criminal sanctions for non-compliance with the NPO Act. This proposal affected churches because they fall within the NPO Act's definition of what an NPO is. Thus, the initial version of the bill would have forced churches to mandatorily register with the DSD, or the pastor could end up going to jail. Another important aspect is that initially one of the unforeseen consequences of the bill would have been to allow DSD to request that changes be made to the constitution or founding document of a religious organization, which would have opened the door, yet again, to state regulation of religion. Now, 4SA put forward proposals to firstly prevent blanket mandatory registration and the imposition of criminal sanctions for non-compliance with the NPO Act. And although the bill has now been passed into law, we are very pleased to report that Parliament incorporated the most significant of our proposals in the final version of the bill now act, thereby mitigating the worst risks to the NPO sector. So, Daniela, how would you describe the implications of the Anti-Money Laundering Amendment Act in a nutshell? For example, who needs to register and how does the registration work?
So, Liesl, as you and our viewers may know, up to now, the registration of nonprofit organizations, so those voluntary associations, trusts, nonprofit companies that fall within the NPO Act's definition of what an NPO is, could voluntarily decide whether or not they wanted to register as an NPO with the DSD. So if churches then want the DSD to start requesting changes to their constitution's provisions, they were free not to register. And if they didn't think that it was worth registering as an NPO because of all the additional reporting requirements, they were free not to register as an NPO with the DSD. However, from the 1st of April 2023, and this is not an April Fool's joke, this is legit, the Act is set to become fully operational. And this means that in terms of it, certain categories of NPOs will have to register with the DSD's NPO Directorate or face administrative sanctions. Now, I want to say that administrative sanctions are a great improvement from the initially proposed criminal sanctions. So thank goodness no one is going to be going to jail. This does mean, however, that churches that fall within the category of affected NPOs have until the 31st of March 2023 to register. So, of course, then the important question becomes, okay, well, what categories are affected NPOs? Well, in simple terms, it is one, if as a church, you make donations to individuals or organizations outside of South Africa. So, for example, if your church sends money overseas to other congregations or churches, or sends money overseas to support missionaries, then you are an affected NPO and you need to register. Or if your church provides humanitarian, charitable, religious, educational, or cultural services outside of South Africa. So if your church sends people to help in a humanitarian crisis or sends missionary overseas, then you need to register. Now, this means that even if you are already registered in terms of other laws, such as being registered with SARS as a PPO, or with the Master's Office as a trust, or with SIPC as a nonprofit company, you will now also have to register with the DSD's NPO Directorate.
Yes, that's very important to remember. And of course, there are the registration requirements that you will have to meet, and these are set out in Section 12 of the NPO Act. Now, 4SA has published an article on this topic on our website, which provides a link for affected NPOs to register online by visiting the NPO Register website. and also a link to an informative video on the registration process. Another consequence of the Amendment Act is the additional reporting and compliance requirements that religious organizations that are now required to register will also have to meet. And as we've said, churches need to register with another entity on top of their registration with other entities such as SARS. So this means practically that a church that is registered as an NPC with SIPC, let's say for argument's sake, and also registered as a PBO with SARS will now have to also register with DVD. So you're looking at 3 separate entities, and you need to do the necessary reporting and meet all the administrative requirements as well. Turning specifically to discuss the DSD reporting requirements, both new registrants and those organizations already registered under the NPO Act need to comply with the reporting and compliance requirements of the NPO Act. And these comprise of keeping accessible accounting records and reports, and providing these with other information such as the particulars of the organization's office bears, its physical address for the purpose of serving legal documents to the NPO Directorate on a continual basis. Daniela, how does the Act affect the protection of religious organizations that now have to register? How are they protected from state interference?
That's a very good question, Liesl, especially because we said, the initial version of the bill would have made state interference possible. Now, the good news is that Parliament adopted 4SA's proposal to protect the founding documents, such as constitutions of churches, from state interference. Now, this is an important victory because these founding documents often reflect the religious organization's beliefs and doctrines. So, for example, who gets to be a member, when membership, what are the requirements for membership, when you forfeit your membership, when membership gets revoked, who gets to be a leader, what are the requirements for leadership, when is leadership terminated or revoked. Now, the director of NPOs may only require a registered religious organization to amend its constitution in very limited circumstances, none of which are likely to pose a risk to that organization's right to religious freedom, which, as we know, is your right to not only believe as you choose, but then also to live out your faith publicly without fear of persecution or prosecution. Now, it's also important to note that religious organizations and other NPOs affected by the Amendment Act must be aware of the implementation timeline. And as we've said, churches that fall in the category of affected NPOs, in short, those that send money or people overseas, have until the 31st of March 2023 to register. Now, in addition to this, the DSD has confirmed that it will be publishing draft regulations for public comment, and that once the public participation process is completed, it will publish the final regulations, which will then also serve as an implementation document. Now, until such a time as the draft regulations are published for public comment, 4SA can't advise what they will say, but they will likely deal with the implementation of the Amendment Act and the practicalities surrounding that implementation. However, these draft regulations and the public comment process surrounding them does not affect the requirement to be registered, though. And 4SA encourages every church to go to www.frsa.org.za and read the article on this topic, which provides a link to register online as an NPO, and to an informative video, which is specifically on the registration process. And as always, 4SA will keep our constituency informed of any developments. Liesl, can you sum up the implications of this new law on the religious community? And are there any next steps that we need to be aware of?
Well, firstly, Daniela, it's very important to note that affected religious organizations have until 31 March 2023 to ensure that they are registered and they do comply with the amended NPO Act. This includes registering with the NPO Directorate and meeting all reporting and other compliance requirements as set out in the NPO Act. And also, secondly, the public engagement process on the upcoming draft regulations. That is another important opportunity to ensure the maximum protection of freedom of religion, Section 15 of the Constitution, and also related constitutional rights, such as freedom of association and freedom of expression, to ensure that they are upheld.
Thank you, Liesl. We trust that you have found this discussion useful. For those who are interested in knowing more about religious freedom and the issues that we're currently facing in South Africa, we can refer you to our website at www.frsa.org.za. And you can also join 4SA as an organization, make a donation, and then, of course, you can also follow us on social media on Facebook at Freedom of Religion SA. Until next time. Good day. This is Daniela Ellerbeck. the legal advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.